Hello, and welcome to the LLG Grapevine podcast. You're listening to Dennis Hall, LLG Bulletin Editor. Well, it's just me at the microphone this week, as most of the team were up in Durham at our spring conference. And if you missed day one, don't forget that you can access it on demand via our new website. Now, I'll start this week with a deeper look at that new procurement bill that I mentioned last week, then take a look at scrutiny in Parliament. I'll then examine what we might expect in the new data reform bill. There have been two surveys, one on lawyers and stress, and the other on remote meetings. And I'll round off with an item on the role of in-house lawyers and climate change. So here goes. We looked last week at the government's ambitions for its new procurement bill. Let's look now into some of the detail behind those recent announcements. First, some key points. The Public Contracts Regulations 2015 are to be repealed entirely. There will be a new approach to transparency, different procedures and procurement processes, and new provisions governing post-award, legal challenges, and enforcement. There will now be a single Procurement Act for the whole of the United Kingdom governing all types of procurement. Once enacted, it will be brought into force by secondary legislation. The UK government has said that it will provide contracting authorities with a 6-month adjustment period. Now, Clause 11 of the bill lays down a general duty of equal treatment, but no general duty of transparency. Most importantly, new-style tender notices to start a process must contain prescribed information about the tender process that is planned. Post-award, a contracting authority must provide an assessment summary of the bidder's submission, and then publish a contract award notice. But much of the detail is yet to be revealed on all of these aspects. Post-contract, the contracting authority must publish a contract details notice containing details of the contract terms. The bill introduces new rules as to the design of a public procurement process. In many respects, the new rules introduce new flexibilities, which are to be welcomed. The contract is to be awarded to the supplier that submits the most advantageous tender, and this is to be judged by reference to award criteria that can be drawn very broadly, and would apparently permit price only, quality only, or even perhaps social value only approaches to the award of contracts. And for light touch contracts, there will be a higher financial threshold as at present. However, even for contracts above the threshold, there will be no minimum time periods during the process, no mandatory standstill period following award, and no apparent restrictions on modifications of the contract. However, new rules will require contracting authorities to consider whether procurements should be subdivided, and above certain thresholds, KPIs will be mandatory. Now, the provisions for legal challenges remain broadly similar, with many similarities to the existing regime. Claimants will retain the ability to seek damages. Claimants will also retain the ability to seek a declaration of ineffectiveness, now to be known as an order setting aside the contract. And of course, there is much more detail in the published bill, and we will report further on all of these provisions as the bill begins its journey through Parliament. My second item is about the importance of scrutiny. There has long been recognition that there is a proper way to develop public policy and to take decisions, and in particular, that the process of development should wholeheartedly embrace effective means of scrutiny. Yet, in a report entitled What Next? The Growing Imbalance Between Parliament and the Executive, a parliamentary committee in the Lords has said that it was very concerned about the government using practices in the last parliamentary session that curtailed Parliament's ability to provide effective scrutiny as part of the legislative process. The committee said that it was especially conscious of the reduced scrutiny in the previous session in the context of the Brexit Freedoms Bill, which, according to the government, will accompany a major cross-government drive to reform, repeal and replace outdated EU law. The committee said, given the volume of retained EU law, it is important that Parliament's role in scrutinising legislation, especially as regards secondary legislation, should not be in any way weakened by the government's ambitions for reform in this area. It also found that as the need to take emergency action in the wake of the COVID-19 pandemic receded, the committee continued nonetheless to see statutory instruments that were brought into effect immediately without any justification and with a failure to consider concerns raised by the Lords. Another theme identified by the committee in the last parliamentary session was the failure to provide information on the impact of legislation. And the committee also said it found a number of examples in which the government offered poor quality explanations of legislation coming forward. The reorganisation of Cumbria was a case in point. The committee said that the Department for Levelling Up said that unitarisation should always be locally led and command a good deal of local support. But the explanatory memorandum to the regulations introducing unitarisation in Cumbria made it clear that the only proposal to have received support from a majority of local respondents during the consultation was not in fact implemented. Now, all of this matters to us in particular because our own constitutional mechanisms quite properly require scrutiny during the development of policy and the taking of key decisions. It is essential to good governance that scrutiny is never ignored. Now back to that Queen's speech. It included a new data reform bill which is predicted to make sweeping changes to the UK General Data Protection Regulations, or GDPR. While the draft bill will be published this summer, much of the contents can be predicted from previous announcements. In particular, government has made no secret of its dislike for the GDPR. Its consultation paper last September, entitled Data: A New Direction, was seen as an attempt to water down the UK GDPR, just a few months after the UK received adequacy status from the European Union. The Prime Ministerial Task Force on Innovation, Growth and Regulatory Reform, in its report, set out a new regulatory framework for the UK, saying that the current data protection regime contained too many onerous compliance requirements. At the very least, then, we can expect the accountability requirements to be relaxed, as has been trailed in the consultation document. The government wants to allow data controllers to implement a more flexible and risk-based accountability framework, which is based upon privacy management programs that reflect the volume and sensitivity of the personal information they handle and the type of data processing that they carry out. So, to this end, the bill is expected to remove the requirement to designate a data protection officer, to review the current record-keeping requirements, and to review the need to report a data breach where the risk to individuals is considered not material. And of course, LLG will report further on this when the bill is finally published this summer. It was reported in the Law Society Gazette that a poll has found that 9 in 10 lawyers have experienced stress or burnout at work, with more than a quarter suffering on a daily basis. The survey of more than 100 practicing lawyers conducted by YouGov this spring appears to confirm that mental health and well-being have become the biggest issues facing the legal profession. Almost 2/3 of lawyers feel that their job has had a negative impact on their mental and physical health, but less than 25% feel supported by their firm when they're stressed or burnt out. More than half suggested that their firms need to offer more support. And the biggest issues contributing to stress are a high workload and the work done not being recognised. This was cited as the main reason for half of those who are considering their future. Respondents to the survey came from a variety of sectors, but were mostly from corporate, litigation, and real estate law. Many firms are already acting to address staff well-being and reduce the likelihood of burnout. Policies requiring emails to be turned off after a certain time or sent on a time delay so that they're received in the morning are increasingly common. Now, this picture raises many questions for those who manage legal departments and specialist teams in our sector too. Do you have measures in place to deal with stress? Are they working? And is this an area where managers themselves need support? I'd like to turn now to the question of remote or hybrid council meetings. Nearly 9 out of 10 county councillors would like their council to be able to adopt a hybrid setup going forward, a survey by the County Council's network has found. More than 2/3 of respondents to the survey said that moving to a hybrid model could attract more younger people, ethnic minorities, and women to stand in local elections. A majority of respondents said that adopting a hybrid model would make it easier for them to attend more meetings. Commenting on the survey results, Councillor Julian German, the rural spokesperson for the County Council's network, said, "One of the most defining features of the first lockdown was the rise of video conferencing, and councils embraced this technology, turning the way they operate upside down almost overnight, with meetings going virtual." Earlier this month, LLG and ADSO expressed disappointment that the government has still not responded to the call for evidence on local authority remote meetings, which was held from March to June 2021. In a statement, the two organisations said, "The case for remote meetings has been made strongly by our two associations, by councils at all levels, local government bodies and organisations such as Mumsnet. And following the May local elections, a new cohort of ambitious and forward-thinking councillors will want to be the most effective and productive representatives they can be, with the most modern facilities available to them." Imagine their confusion then, and their frustration, when they realise that in a digital age, the opportunity to harness new technology to conduct meetings in a flexible and innovative way, and to promote ease of public access and engagement, is simply not an option, as it is across almost every other sector of our society, including Parliament and in Wales and Scotland. This issue remains unfinished business for LLG and ADSO, and the necessary changes in the law need to take place to make progress on this important issue, which is simply not going away. Now, before COVID and before Russia invaded the Ukraine, our dominant focus was moving towards climate change and what we can each do about it. A Law Society Gazette article argues forcibly that in-house legal teams are uniquely placed to influence their organisation's response to the climate crisis. And this came from senior legal chiefs speaking at a Law Society flagship conference for in-house lawyers. Dozens of lawyers attended Chancery Lane last week to hear a keynote address on how they can drive the environmental impact of their employers' environmental, social and governance strategies. Last year, the Law Society published a climate change resolution to support solicitors to develop a climate-conscious approach to legal practice, pointing out that nearly a third of the UK's largest businesses have pledged to eliminate their carbon emissions by 2050, and requiring those who they do business with to adopt similar measures. In-house delegates were told that climate and environmental issues presented challenges and opportunities that required leadership. In-house lawyers can be those leaders. You are often in the room when organisations are dealing with key strategic issues. The best in-house lawyers understand their businesses, as well as the legal requirements to balance risk with opportunity. Now, while these messages were largely directed at General Counsel and in-house commercial concerns, the role of local government lawyers in influencing the consideration of climate change questions is much, much more impactful. In most cases, you sit at the strategic level. You influence governance. You advise on specialist areas like planning and environmental law, and you draft commercial documents in diverse situations. It is up to you to seize the opportunity to make a difference to the biggest challenge facing us. And that's it for another edition of the podcast. You can read more on this and the other items discussed today by going to Bulletin 19, available now on the LLG website. Now, day 2 of that spring conference is online on Tuesday, the 7th of June, so don't miss it. And even if you do, just watch it on demand. Do have a good week. Bye for now.